thank you for your very interesting presentation. Maybe too complicated for my little mind. No, I'm joking, but the halakha is, we are here in Israel in another legal culture. If we think about the biblical legal culture, so the halakha is a great problem because the theological background is very, very strong, and for us it's a little bit difficult to understand this kind of. But anyway, we will speak about this. So, Zoe Cunningham, you have a Greek name, Byzantine. She has studied in Aberdeen, in Scotland, and now in Exeter, yeah? And now in Exeter. The title is The Custom of Other Countries, the Influence of Italian Customs on the Transition of French Jurisprudence in the 15th century. Okay.
Thank you. In 1481, Louis XI, King of France, sent a letter to one of his courtiers, Bouchage, requesting an examination of the customs of Florence and Venice. Quote, Monsieur de Bouchage, you know well how eager I am to organize our customs in terms of justice and the good administration of the kingdom. And in order to do this, I must have information about the running and customs of other countries. I ask you to send for the little Florentine to find out about the customs of Florence and Venice, and make him swear to keep all this secret, so that he can tell you in more detail and so that he commits it to writing. My PhD is a study of the consciousness of custom amongst rulers in the late Middle Ages, and thus the content and rhetoric of this letter is of interest because of the evidence which it provides for the longevity of this consciousness of custom amongst rulers in this period. This proactive interest in foreign jurisprudence, which includes a specific reference to custom, is a strong illustration of the values of figures in Louis' position. Louis plausibly demonstrates a consciousness of law as custom, and the rhetoric of the letter is arguably a product of this custom. This consciousness is distinct from the culture of formal jurisprudence, which had apparently become dominant in the late Middle Ages. This letter represents a significant point in the transition of the legal system of France in the 15th century. It was first noted by John P. Dawson and further discussed by René Gandillon in the 1940s, both of whom published articles on the unification of the customs of France by Louis XI in this period, several centuries after it occurred in other territories. Dawson only acknowledged it in a footnote, but Gandillon observes that it is evidence of Louis' autocratic direction of this project, ignoring the position of the Grand Council. This observation is the most plausible cause for Louis' demand that the mission be completed in secret. It is also plausible, however, that Louis intended to avoid the attention of the Venetians and Florentines, although the justifications for this point are not very persuasive, although they are tenable. The possibility that Florentines and Venetians were reluctant to have foreigners reading their laws is not that convincing, because these texts were public documents. It is also plausible that the existence of, or perhaps more plausible, that the existence of political tensions between France and the Italian states in the late Middle Ages might have made the Venetians and Florentines suspicious of any activity comparable with spying. In the 15th century, the Venetians were very concerned by security and espionage, and often perceived ambassadors as legalized spies. Tensions did in fact exist between these parties in the 15th century, and this mission, as we have seen already, was apparently, however, delegated to a Florentine, and thus the transparency of his task in the eyes of these foreign governments is not obvious. Thus, it does seem that this endeavour would be kept secret from other Frenchmen involved in the programme, although this interpretation does not account for the plausibility of members of the Council not noticing the insertion of foreign customs into the codes of France. So really, I think understanding these dynamics of the situation probably requires a lot more further study into the general process of codifying the customs of France. Oddly, an element of this letter which seems to have escaped the notice of scholars is Louis's particular interest in Florence and Venice. The rationale for this interest is not obvious, but it was probably encouraged by familiarity with specific legal texts and a belief on Louis's part that the situation of these jurisdictions was comparable with France. In the Middle Ages, the city-state of Venice was an imperial power. By the early 15th century, it achieved overlordship of settlements on the terra firma, which is sort of the land of Italy near Venice. Since the 14th century, the Avogaria de Commune, Council of Nobles, had responsibility for collating and editing the laws of this territory. The Venetians developed this practice of codification unusually early in comparison with other jurisdictions, and this precocity might have attracted the notice of observers abroad. The expansion of Venetian dominion in the early 1400s to include land on the terra firma complicated the infrastructure of it. An unbalanced assortment of customs and legislation with different applications across the territory required harmonization. This revision of Venetian jurisprudence might itself have prompted Louis's interest, because he desired a better understanding of how this major endeavour was achieved. And the code produced by this council, the Promissione Maleficorum, was also circulated across Europe in the 15th century. This, albeit brief survey of the suitability of Venice as a model for legal reform in France, also parallels the situation in Florence. The Florentines had attracted the attention of the Parisian court from early in the 15th century after becoming entangled in the Italian wars as supporters of Charles VII, supplying aid for his campaign to win Naples from the Spanish. As Louis seems to have had an interest in foreign jurisprudence on principle, the close relationship between these territories might thus have highlighted the existence of Florence as an option for comparison. And in addition to this, the legal system of Florence was an especially useful model for it, because the government enforced a particularly proactive and harsh administration of justice in this territory. And after centuries of ineffective administration, the King of France was arguably quite interested in following the lead of a more successful government. In the 13th and 14th century, France was a splintered conglomeration of territories which had individuated and often complex relationships with the crown. The royal domain was nominally under the control of the government, but the numerous fiefs and appanages on the periphery of it enjoyed varying degrees of autonomy, which occasionally conflicted with the policies of the crown. This fragmentation inevitably reduced the opportunities for the government to develop the administration of France, and most of its efforts were focused on increasing revenues from taxation, an objective which it struggled to achieve. In other territories and jurisdictions, this period is notable for the codification and promulgation of legal systems, but quite strikingly, as mentioned earlier, this did not occur in France until the 15th and 16th centuries. Although a few private codifications of custom were produced by jurists in the 13th century, but this activity declined during the 100 Years' War. A conflict which disrupted many activities in this territory and further strained relations between the king and his vassals, notably the Duke of Burgundy. The evidence from letters and other documents, however, suggests that the end of the war in 1453 encouraged the king, Charles VII, to organise the codification of the customs of France. So the cultural and political circumstances in which this event occurred offer valuable context and might explain why the jurisprudence of these cities was preferred, Florence and Venice, over other territories which produced similar legal materials. The final topic in the analysis of this letter is the persons mentioned in it. Bouchage was the title of Imbert du Bartenay, lord of that particular territory of Bouchage, and Bartenay was one of Louis's senior courtiers in the 1470s. But the identity of the little Florentine is more problematic and still requires speculation. The most plausible person which I can currently imagine is Donato Aculi, a gonfaloniere and ambassador for the city of Florence in the late 15th century. This description is plausible for several reasons. Firstly, in 15th century Florence, a gonfaloniere was a judicial officer, and the holder of this position would thus have extensive knowledge of the legal system. Seemingly significant circumstantial evidence also indicates that Louis was familiar with Achille and perhaps met him on at least 2 occasions. In a memoir of his tenure as the owner of a prestigious bookshop in Florence, called Lives of Illustrious Men, Vespasiano Bessisi reports that in 1461 Achille had attended Louis's coronation as ambassador of Florence and presented the king with a manuscript of The Life of Charlemagne, a text which he apparently produced himself. In 1472, a Florentine ship at port in Milan was captured by France, and Achille was sent as an ambassador to negotiate the release of the ship. Achille was in Bessisi's probably rose to his vision, greeted as a friend by the king. Louis granted Achille's request and also asked him, in Bessisi's words, to read certain letters that I have received from Spain. This anecdote, which is inevitably narrated in the hagiographic style of medieval profiles, indicates that Louis XI was possibly acquainted with Achille, knew the intellectual capacity, and probably also his legal qualifications, and retained a favourable impression of him in his mind. The principal obstacle for this ascription is that Louis sent the letter in 1411. Achille seems to have died in 1478. But this discrepancy is not necessarily problematic, because communications in the Middle Ages were obviously not comparable with modern equivalents, and it is thus very plausible that even if Louis was at one point familiar with Achille, he remained ignorant of his death. The description of him as a little Florentine also suggests that this familiarity was a distant connection, and might have been a distant connection, and Louis only had enough information on him to believe that he was a suitable agent for this mission. And it is also finally plausible that Louis was not familiar with him at all, and an appropriate person was only suggested to him by his advisors. Although I think that's perhaps unlikely. This argument obviously requires further study on the correspondence between Louis and Bouchage, and indeed any other relevant individuals in this episode. But in the absence of other evidence pointing towards an alternative identification, however, I believe that Achille remains a plausible conclusion. Finally, the codification of customs of France in the 15th century is a very notable point in the history of legal transitions, because a territory which had not participated in the general expansion of codification in earlier centuries, and which had become, in comparison with other jurisdictions in this period, notably less developed, was now embarking on arguably one of the most systematic programs of codification in the Middle Ages. This review of Italian jurisprudence is a significant event in that episode, because it highlights the particular factors in the consciousness which govern the application of this transition. Louis was evidently very involved in this program and possibly dissatisfied by the progress of his officials. He also had a strong interest in foreign jurisprudence and believed that these customs were compatible with the extant legal values and traditions of France. The success of this endeavour, whether Italian jurisprudence was actually consulted and even incorporated into the laws of France, and the reception of this act by French jurists requires still further research. Nevertheless, I think the content of the letter is important evidence for the legal consciousness of Louis, which seems to have included the ideas of jurists and jurisprudence of other territories.